Now, the Ghana Mine Workers Union is warning of an upsurge in illegal mining in the Tarkwa area in the western region if Goldfields Ghana goes ahead with its plans to lay off 1,700 workers. The workers claim a planned restructuring program by the company will leave lots of workers out of job. They have petitioned parliaments to intervene. Goldfields, on the other hand, says it cannot continue to keep up with the unrealistic salary demands of the workers, as they have gotten a 60% rise over the last 4 years. But the workers are disputing this. General Secretary Prince William Ankwa says a larger chunk of the money has gone to senior management officials. Now, that is how the issue has been playing out since yesterday. Let's go on the phone lines now and speak with labor expert Senyor Ejabing on these developments. Good morning, sir. Thanks for joining us.
Good morning.
So, so far it's been a back and forth between the workers of Goldfields Ghana Limited and the management of Goldfields Ghana Limited. And an impasse like this, as a labor expert, what would be your initial advice?
Well, I believe that the parties need to engage more, because it might seem that not much information has been exchanged between the parties, and so there is some miscommunication and some initial disagreements as to even the reasons for the layoffs in the first place. So I would say that the parties need to calm down, sit around the table and bring out the issues and talk more about the issues that they disagree on and to reach an amicable agreement.
Now, the gold price has been going down. The company complains that it's dropped by about some 10%. Salaries have gone up by about 60% over the past 4 years. And the workers are saying that, look, these salary increases have gone to senior management officials. Who has a case, really?
You see, there is no law that prevents an organization from undertaking redundancy exercises. So it's difficult to prevent an organization from restructuring and reorganizing the business in a way that makes it profitable. That is the right of an employer. However, there are procedures that must be followed should an employer decide that they want to restructure or reorganize. Under such circumstances, the framers of the law found it prudent to give a 3-month prior notification, which is supposed to be like a consultative notification, to start talking about the entire process, dialoguing on things that can be used to mitigate the job losses and alternatives to the processes, if anything can be done to avert, job losses and all that. So that 3-month window is very important, except that sometimes employers are in so much of a hurry to quickly circumvent that aspect of the law, to put in notices for redundancy and also laying off of staff, and that creates a lot of problems within the parties' relationship.
Also, the company's position is that immediately after some workers are laid off, of course, the company is saying that not all 1,700 may be laid off, but even those who are laid off, 85% of them will be retained under a different arrangements, possibly under contract arrangements. Will this be legal, looking at the fact that the Ghana's labor law puts a cap on the amount of time that a worker can be kept on as a contract or a casual worker?
Well, those are the technical areas of the exchanges that must be worked out. But realistically, what I believe the organization wants to do is to outsource aspects of its operations. Therefore, it lays off workers in these areas of the business, and then it kind of hands over the workers to an agency or the new contractor. Now, that is legal in its sense, except that the right compensation for job losses and for the change in contract of employment must be worked out. so that the both parties walk away from the table with something substantial.
But the point here is that would it be legal to keep these workers as contract workers in perpetuity?
Well, once a worker loses the right to be permanent employer, it is then difficult, to say that an employer cannot then decide what else should be done. The employer would not have an employment relationship with the employee, so that would be an issue between the new employers and the employees. But the fact is that contracts of employment or fixed-term employment is legal within the context of our Ghanaian labor law.
In perpetuity, is my question. This is a company that intends to come and take over the concession of Goldfields Ghana Limited. The company has made no indication, or Goldfields has made no indication, that these workers will be kept on as permanent workers. But we know that it's the arrangement that in most companies, workers are kept as contract workers and the contract keeps getting renewed and they don't get any health insurance in some cases. In some cases, they don't get any provident fund. In some cases, there's no other benefit. Is this legal?
Well, in perpetuity would be right or wrong, depending on the terms of the specific fixed-term contract. Fixed-term contracts are legal. Depending on the structure of the work and the job content, contracts of employment are expected to be developed and drafted in line with the type of work. And therefore, where you have types of contracts where the employee then suffers some form of termination, then it may not be right. So I would not say that it is wrong to issue fixed-term contracts in line with a particular type of job, which, for example, may be contractual. But it is the content of these fixed-term contracts that would determine whether, the employee is benefiting or not, or whether the law is being breached or not, or whether the rights of the employee is being infringed upon or not.
Right. Thank you very much, Mr. Stenyo Jabing, for joining us. He's a labor expert, giving us his thoughts there on the impasse between the Ghana Mine Workers Union and Goldfields Ghana Limited.